This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
You're listening to Bloomberg Law's Intellectual Property Review. I'm Josh Block. Early next month, a dispute will be argued at the Supreme Court that may change how brand name drug makers use patent law to delay competition from generic drug makers. Coming up, we'll look at the lawsuit over provisions in the law that provides the process by which generic drug makers get approval to sell their products. I'm joined now by Tony Dutra, a writer and editor of BNA's Patent, Trademark, and Copyright Journal. Tony, the Hatch-Waxman Act provides the process by which generic drug makers apply for FDA approval. How a particular provision in that act is applied is the issue that's coming before the Supreme Court. What is the drug that Novo Nordisk developed, and how is it being used?
You're correct about the Hatch-Waxman Act, and it is a number of provisions that, when combined, cause the problem in this case. The drug is called Prandin. Its chemical name is repaglinide, and it lowers blood glucose by stimulating the release of insulin from the pancreas. Prandin is manufactured and marketed by Novo Nordisk, and it's sold to the tune of over $150 million in 2010 in the United States. That puts it in the top 200 drugs in terms of revenues.
What were the uses covered by the patent, and what are the other uses?
The original patent on repaglinide expired actually in 2009. What Novo did was to get subsequent patents after the original patent was filed, covering the combination therapy of repaglinide together with an anti-diabetic drug called metformin. It was also approved for use alone and approved with a third drug. The question in this case came up because this patent now doesn't expire until 2018, and the Food and Drug Administration, which files in its Orange Book the listing of patents that cover drugs, brand name drugs, originally said that they were only going to cover that use with metformin.
Who is the generic drug maker here, and in this case, what were they trying to do under Hatch-Waxman?
The generic drug maker is Caraco Pharmaceuticals. They're based in Detroit. They filed an abbreviated new drug application, which a generic manufacturer wants to do to produce, in this case, generic Prandin. And under Hatch-Waxman, Novo was then required to file an infringement lawsuit against Caraco. So Caraco now has to file what is known as a paragraph 4 certification that originally just says, I don't intend to infringe the patent. And what Caraco meant by that is they didn't expect the label on their drug to say, use this with metformin. So if that had all turned out in their favor, the Orange Book listing would have said this drug, the patented drug, only is for combination with metformin, and Caraco's drug is not for use that way. So they wouldn't have infringed.
What did Novo Nordisk do once Caraco, the generic drug maker here, informed the FDA that they would apply to use the generic version of this drug, Prandin, for other uses?
There's a little bit of a debate about exactly who did what at this time,
Okay.
But at Novo Nordisk's request, the FDA changed the use description on the drug, Prandin, so that it was broader. It wasn't simply to be used with metformin. It was to be used as an anti-diabetic drug. And Caraco contested that, wanted the original label, which again excluded other uses besides with metformin. And the FDA further, and again a question of who asked this to happen, further said that Caraco could not produce a label that said this is not for use with metformin. So Caraco was unfortunately in both cases unable to say I don't infringe. Now it had a label that said this is for all uses, including with the metformin. And the Orange Book had a use description that did not say it specifically for use with metformin.
Now, is this process, this back and forth between a generic and a brand name drug manufacturer, is this a common pattern being used?
I'm not enough familiar with the history of the Orange Book to know that. What I do know in this particular case is that the FDA actually changed what it wanted done on anti-diabetic drugs in 2009. And so at least Novo Nordisk's argument at this point was they were only doing something that the FDA wanted. What you should recognize is that the FDA really doesn't have patent attorneys in their offices, so they rely on brand name manufacturers to tell them what should be in the Orange Book. I suspect that there's a little bit more vetting before it goes in, but not much.
And this is, I think, where litigation begins. And what happens when the case gets to court?
Carico invoked what is called the counterclaim provision, which is essentially contesting the patent information posted by the FDA. Carico asked a Michigan district court to order the FDA to change the use code back to the original, and the Michigan court, in fact, did agree with Carico. They said yes. Novo appealed. It went up to the Federal Circuit, and the Federal Circuit reversed in a 2-1 decision. Not only was it a 2-1 decision, there were 3 panelists, and each of them published their own opinion at this point. Quite a debate there.
What are the ramifications of this case? If Novo Nordisk wins here, what will it mean to generic drug manufacturers, to consumers?
The support in the briefing at the Supreme Court is pretty obvious. The Generical Pharmaceutical Association supports Carico, and the Pharmaceutical Research and Manufacturers of America Association supports Novo. So this is clearly, if Carico can win, a plus for the generic makers. What is happening going forward here is that a lot of these patents that were granted originally on the drug alone have been updated with patents on methods of use. If the generic drug makers can't challenge these use codes that are getting included in the Orange Book, the generic manufacturers really always are kind of in a terrible state about the infringement aspect of the litigation. So if they are able to do this and successfully challenge the FDA on use codes and get the FDA to make changes on use codes, they can do it through an administrative procedure, first of all, much cheaper, and second of all, much more likely to have a meaningful impact. If these things go to court, the current Hatch-Waxman Act does not give a court any power to tell the FDA, change the use code, so that this isn't infringing.
You reported in a recent article for BNA on the various briefs coming into the court to support each side. What are the best arguments being put forward to support each side? 2
killer amicus briefs at this point were on Carico's behalf. First, the Solicitor General submitted a brief. This is representing the government now, and that brief says that there was a careful balance in the Hatch-Waxman Act between generic makers and brand name makers, and that brand name makers over the course of the years, remember the Hatch-Waxman Act was approved in 1984, and up to 2003 when this counterclaim provision was added, the argument goes that brand name manufacturers had started abusing the system by convincing the FDA to do things that they shouldn't have done. So the Solicitor General now said the balance has shifted, and the counterclaim provision was a way to restore the original balance. Probably more significant for Carico's argument was that one of the original co-sponsors of the Hatch-Waxman Act, Henry Waxman of California, submitted a brief in support of Carico. What Mr. Waxman said was, I know what we intended when we put in the counterclaim provision, and what we intended is not what the Federal Circuit says we intended. So if this case does come down to a pure statutory interpretation issue, that's a fairly powerful argument on Carico's part. Now, if you take the argument that Novo is putting forward, Carico's not necessarily a completely innocent player here. The Carico knows full well that when its generic hits the market, a physician can prescribe an off-label use. And so if Carrico wants a label that says don't use this with metformin, it doesn't mean it won't be used with metformin when it finally gets into the market. And so those arguments are the ones being put forth by the amicus briefs supporting Novo in this case, which were filed by the Pharmaceutical Research Association of America and other brand name manufacturers.
Can you handicap the court on this one? Is there any indication from past rulings how the court might come out here?
The caveat to putting so much weight in Representative Waxman at this point is that the court just recently made a decision in Stanford v. Roche, which was a case that revolved around the Bayh-Dole Act, which has to do with university patenting. And Birch Bayh, one of the co-sponsors of that bill, originally sent in an amicus brief favoring Stanford. Well, Stanford lost in that case. So the court doesn't always take what the sponsors say is a statutory interpretation. And that's what I think is going on here, is that the statutory text is the thing that's going to drive the case. And in past actions by this current court, the textualist folks on the court, namely Justice Scalia and Thomas Mosley and others, have been voting 5-4 quite often in favor of a very strict interpretation of the text. And Federal Circuit pretty much, the 2-1 decision of the Federal Circuit pretty much said, this is what the text says, and that's why Carrico loses here.
That's Tony Dutra of BNA's Patent, Trademark, and Copyright Journal. You can read more about this case, including the complaint and other court filings, at BloombergLaw.com. You can find new IP podcasts every Tuesday at YouTube.com/BloombergLaw, iTunes, and on the Bloomberg and Bloomberg Law websites. Thanks for listening.
Copyright 2011 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take responsibility for the content contained herein and do not make any representation